And this is an ambitious target, but I would like for it to be done within 1 year from the time we start.
Thank you. Okay, any more public questions, comments? Okay, well, thank you. Let's go to item 6I, General Services Administration, Capital Improvement Projects and Facilities Report. Discussion and possible action by Mr. John Hopkins.
Afternoon, John Hopkins, General Services Director, Madam Chair, members of the board. This is just that bi-monthly report that you have before you. I gotta get my glasses on. And hopefully you've had a chance to maybe peruse through that a little bit.
Yes, and we've seen it before, too.
Pardon me?
Yes, and we've seen it before.
Yeah, you've seen it before. I don't know that there's really going to be much discussion here other than I'd like to just point out to the board the jail control panel project, which I believe you, your last board meeting, you authorized a final payment to that contractor, ISC. But that particular project really went well with the staff, the jail staff, facility staff, the contractor, the engineering. We ended up, as my memo says there, 1.4% under all contracts in total cost, and then only used about 0.09% of total contingencies. And usually you expect 5 to 10% out of those contingencies. This is a project that was under contract about $619,000 and some change. We were under that about $611,000, and a very difficult project for the last 6.5 months because of the conditions that staff and contractors had to work in. Nobody likes to work in a jail today due to those conditions. The jail control panel was extremely outdated, and when you pulled that panel off, there were just literally thousands of wires, and it looked like spaghetti. They had to identify all of that, track all that, but corrections staff, facilities staff, the contractor, and kudos to the design documents as well. Everything went along very well. So I just want to let you know that everybody did a good job on that project for 6.5 months.
Okay, say those numbers again, because were you saying that the total project was 600 and something?
619, actually it was.
119, because that's not on here. At least I'm not saying it.
No, contract price was about $619,945.45, and we were 83.68 under that. So,
okay.
Which makes up that 1.04%. And it's ready to go, fully ready to be integrated with the new jail expansion project as well.
Any other particulars to point out before I open it to the public?
I did have a question, John, on the animal control barn.
Yeah.
Have to put that off. How's that impacting our, our animal control?
We're doing fine. Most of the livestock, if we ever get into a circumstance where we need to impound something, a lot of times we try to work with the owner to keep that animal on site. Rarely do we have to actually impound any kind of livestock or of that nature. So, and they're still working on receiving additional donations for that project that Kelly is.
So an animal control barn is really for large livestock?
Yes.
Like a horse?
Yes.
Elephants.
Sheep, goats.
I hope we don't get it.
Yeah, well, no, I
The
don't.
plans are all ready for it, right, John?
No, they're not ready for it, but there's a concept with it. But like I said, they're still working on donations for all of that. So.
And obviously, a discussion that we've had for several years is the Public Works crew quarters.
Yes, and so right now, as we speak, we've got, I think in July, somewhere around July 11th, the probation carpet project takes off. Currently going on right now is the district attorney's roof project. You can probably go out and see what they've been doing out there. And staff is currently working on, besides all the other unanticipated things in their normal duties, they are working on cost estimates for 3 different options for those crew quarters. We've met with Chuck and the union over those issues. They know where we're at. So once we get out of that scope development, we'll get some drawings done and then move on from there.
But at this point, anyway, you feel that the $200,000 tag is probably sufficient?
Well, I don't have a choice. We're making that work somehow. I will let you know that we did discover we have done some initial things like lead and asbestos testing.
Oh, good.
We did find some asbestos in the mastic roof in the foreman's quarters down there. So if we ever go to disturb that, we'll have to mitigate that first.
That
But
was
right
my
now,
question, what you thought that, if you did, what that might cost ballpark?
well, it's a non-friable material, so more than likely, it would depend on the scope of the project. If I had my way, I would just demo that building, and if we demo it, it's done with an excavator and a fire hose, and we put it in a truck and we take it to the appropriate landfill because of the type of material that it is. So,
Okay, so yeah, you'd have to go like one of those, hazmat sites, what do they call them or whatever.
right, probably go to Reading or someplace like that right now.
Okay, board questions, other board
Yeah,
questions?
John,
Yes,
a
okay.
couple of times in your report, you mentioned that in the maintenance side, that there's a shortage of custodians. Was that retirement, or was that when we downsized, or
It's a
a
combination.
combination?
It's a combination of everything, including personnel actions, right? So when somebody's out for some period of time, like we've had a full-time custodian out since last August. So, but what it does is it shifts to the facility maintenance guys to perform those
So they
duties, which
can't-
also adds to
Their
some
workload,
delays in time.
yeah.
Which was my question, why don't we get that handled? It's just,
Personnel issues, so.
Also, you got looks like a sewer line for sheriff's office that has issues.
Oh, yeah.
Are you trying to see if you can hold off repairs till the other one is built? Is that where so you have a new line or?
We're still working on that. The idea originally was to repair it immediately because of what we discovered. There's actually 3 spots in that line that are completely full of sewage. They don't flow at all. Haven't figured out if it's just because things have settled or trees have pushed the line up. Regardless, there's one 80-foot section that's just full. But it still operates. So the idea
How
is...
does that work?
Yeah, well, pressure. So...
lots of pressure.
So as long as that continues, the idea is that when we launch into the jail expansion project, we're going to tie into that new line and avoid that extra expense of fixing it now.
Think it'll last that long? Is it any?
Well, it didn't occur overnight, so it's been that way for some time. It's just that we happened to discover it when we were potholing out there. And so, I don't know, I probably talked to Chuck about it 4 or 6 months ago. So it's probably been in that condition for several years, if not longer. So as long as it continues, it's not backing up, and usually we get a backup because of an inmate feels the need to put something down a toilet that doesn't belong there, that's when we have trouble. But right now we don't have any trouble with still pushing that sewage down the line. So as long as that happens and we can incorporate it into the state project and get reimbursed for it, that seems like a better economic strategy right now. But if it changes, yeah, we got to act.
So the card access system has been entirely replaced?
We're done.
Good.
Yeah.
Any other board questions before I open it up to the public? Hey, any public comment? Yes. By the way, board, we're pretty close to being through the regular agenda here.
When this jail project first started, one of the first questions I asked was the sewer adequate? And I was, no problem. I think that was on the mitigated negative deck, that there was no problems with it. I just want to know how much delayed maintenance has gone on for it to have been allowed to get 80 feet worth of backed up jail colon, and then usually when this happens, there's breakage and there's seepage, and it's probably contaminating the area there and maybe contaminating the creek. So I'd like to know where it goes, and it's just amazing to me that it's a 6-inch pipe. We have a 6-inch pipe on our property for 2 people, and you have a 6-inch pipe for something like 80 people now, and it's going to go to add another 60 people to it. So where is it all going to go? Is any of it coming onto our property? I do know that a few years ago there was a line break for the water supply, and it flowed onto our property for about 4 hours. We figured you were just having a bad day, and we didn't say anything. It caused a little erosion, but if you're having a hard time, we're not going to try to make it harder. Anyway, have there been no sewer lateral testing to this point where it has gotten this bad?
I'm going to have to ask Mr. Hopkins to answer.
Test for leakage, and, it's a standard thing done in all real estate transactions. So,
Okay, first of all, it's not a lack of maintenance because it's infrastructure, so there's nothing to maintain. The second thing is
wait a minute. What's that?
the second thing is we've put a camera down that pipe at least 3 times. There's no evidence of it leaking whatsoever. It was just to determine where and if there was a problem at all in the line. And obviously, it's not leaking if it's retaining.
And you did the smoke test?
That's where we're at.
The smoke test?
Whereabouts is the obstruction located? Is that something you can share? Or?
Yeah, I've got that back in my office in different locations, but there's 3 different locations in the line. Yeah.
And where is it in relationship to our property?
That sewer line's our property is adjacent to your property, so.
Well, it's borders 2 parts, your property borders 2 parts of our property. I mean, is it going down toward Court Street? Is it going down toward the other direction?
The sewer line goes directly around into the lower area that we own there below the district attorney into the Court Street.
Into Court Street. Like everything goes into Court Street, and everything from Court Street goes into us. So I know we have a storm sewer problem, but I didn't know we may additionally have seepage from a sanitary sewer.
No, what he's saying though is, and this is not like you're saying you have a 6-inch line. It's probably a good thing for a house, but I mean, it's 6-inch line is a pretty big line to handle.
The what?
6-inch line is a pretty good sized line. It'll handle a lot of water, wastewater.
Yeah, well, it says 6 inches. We have 6 inches on our property. I know this. We just had ours repaired. We had 10 feet repaired under the redwood tree with what do you call it? With a trenchless.
Oh, you did boring?
It was cleaned by a trenchless process, which means someone goes in and bores it and cleans it out.
Roto-rooter or something.
What?
Like a roto-rooter?
Well, it's more complicated. It's more sophisticated than that, but it can be done. And what he goes on to say is if we try to repair it, it'll probably kill the oak tree anyway, therefore we'll just cut it down. Well, I protest it's being cut down. There are ways to fix it without cutting it down. And since we just did it, and I do it all the time, or used to do it all the time in every real estate transaction, when there was a problem, they can do it without taking out an old oak tree. It takes the oak tree 200 or 300 years to get that way, and you want to destroy it in an afternoon. Okay, so in the city of it refers to a presumption that you're going to win in the appeals court, and this is not necessarily true. And the trees are protected until there's a conclusion from that. The city of Jackson has also requested to removal of trees. It says that 2 trees can cause damage to the water main located between the district attorney and the sheriff's office building. it doesn't say there is current damage and who wrote the letter. And I would appreciate it if someone would, you know, John or somebody who works for him would walk me through as much as I can walk, you know, walk me through the area so I know where it is and I can determine how it is and how it might affect my property, our property. Obviously, there's been a lot of poor maintenance, and it will continue to be poor. You don't pay attention to it once it's there. I know one of the grand jury reports a while ago complained repeatedly that there was black mold in some school classrooms, and they thought they fixed it, and it came back again because they didn't do it right, and so on and so forth. And it's important because the Anderson report that you've got in your mitigated negative deck really emphasizes the necessity of really strong regular maintenance because of the difficulties of its being built on a hillside, and there will be some subsidence if it's not cared for properly. Okay, back up to 6I, the jail project. It says John says in his paragraph, I presume he wrote it, that the project has been put on hold while the State Public Works Board considered approval of the county's preliminary plans. Actually, the project has been put on hold because the state administrative manual says that the state DPW cannot work on plans while there is a CEQA challenge pending. The information we received recently from the state under the Public Records Act shows that you've done some very heavy lobbying to cajole the state into breaking its own rules. County council writes something to the effect that this law was never meant to apply to us. And John Hopkins writes that this state might be willing to break its rules if the county would agree to forego any reimbursement if you possibly lose at the appeals court. These letters were submitted to your agenda. This is 460 some pages, 6 days before Christmas, when everybody's going to pay attention to it, right? Okay. And then Supervisor Foster, in a letter to the state, lays the bet. If he were so sure, and it were his own money, it might be an act of bravado, but it's a terrible thing to do, to bet the taxpayers' money, that you could go ahead with things and not be reimbursed if you should lose. And nobody knows what's going to happen in a court of law. I just know that you're very sure of yourselves. Now, I've gone online and checked the job descriptions of the state employees, and in no case can I find anything stating they can act as either judges or as bookies. And they're acting as a bookie for Foster in the county, and they're acting as judges when they shouldn't be. It should wait to go through the due process and wait for the appeals court, and it's improper on both the county's part and the state's part to go forward and approve things that their manual says not to do, listening to one half of setting themselves as judges, listening to one half of the argument. And then my quote that I just said from Felix Frankfurter, the history of liberty has largely been the history of observance of procedural safeguards. That's important. You have to proceed according to the law. Otherwise, you're interfering with our rights on a due process. And it seems to me, for people involved in administrating and enforcing law and order, you seem to have a mind-boggling disrespect for the order of law. What I have managed to get through so far with the state's PRA documents leaves out any mention of the old hospital as a state and nationally protected site. I mean, the question's asked, but it's just negated. And then there's the other thing, because everything it's riddled with errors, and you're only getting one side, and you're presenting what you want. It's almost like the district attorney's withholding exculpatory information regarding a crime, because you're presenting things from your point of view, or your attorney and your guy back here, John, is doing, and withholding things that might be favorable to our side, and you're setting up these administrators as judges when they are not judges. One thing in particular that bothers me is there's a line drawn between the county properties and ours, and it is designated a judgment in bold lettering. Now, this has never happened before, and I've seen some of these signs before. I noticed in the heavily redacted information we got from you last year that when John Hopkins asked Tomo, the surveyor, how the county acquired the storm sewer easement across our property, Tomo misinterpreted the settlement in the 1981-82 lawsuit and called it a judgment rather than a stipulation. It wasn't a judgment. It was an agreement between parties. No judge said we were at fault or our predecessors on the property were at fault. It's an agreement. And you should note in the stipulation between you and Foothill Conservancy coming up next under 3B, mutual consideration, quite beautifully written by, I guess, Michael Graff, was that the quote, the commitment by Foothill Conservancy to abide by the terms of the settlement is consideration for the county's commitment to abide by the terms of the settlement. And the county's commitment to abide by the terms of the settlement is consideration for the commitment by Foothill Conservancy to abide by the terms of the settlement. So there's consideration on both sides. Because basically, it's a real estate deal, and you can't have a real estate deal without consideration. And it seems to think, in putting in the word judgment and a lot of other things, is trying to deny that fact of dealing, real estate deals. And so the same applies to the old stipulation. And the small exchanges of property that happened in 82 that form the property line, it is said, are given in for valuable consideration. Tomo is a surveyor and not a real estate agent, so he might be expected not to know. And John, asking Tomo, said that he didn't know and was looking for information. Good, I'm glad he does. He's curious and wants to educate himself. But I'm an inactive real estate broker, so I know a little more. However, it seems to me that some of you who are negotiating deals for the county, that you should have corrected it. But if you didn't, I mean, you've got a lot of people around who are really good in real estate in this county, and get someone to help you that has a license. So, but I know that it certainly makes our side look bad. However, to have this bold-faced word judgment along that property line. But maybe that is your point, because you are trying to prejudice the state against our cause and go ahead when you're ignoring the due process. So, and I have these in the packet, you'll notice, and maybe the new development plan might like to, general plan might like to look at this, because it talks about light and how you should protect dark skies. This one is a picture in the middle of the day of one light from the sheriff's office that wasn't there 14 years ago when we bought the property, shining down and putting a glare on our swimming pool all day long. I mean, they seem to need to keep that light on all day and night. And here is a night view. We couldn't see any of this when we first bought the place. It was perfectly dark, and you could see stars, and it was simply beautiful. And it really has been disturbed. It's not the beautiful natural place it once was, and you've only started. I should mention that when we bought the place, I paid at least $50,000. We paid at least $50,000 to $100,000 more than we should have, because we wanted to be next to a hospital, because we both obviously have health issues. And we didn't move up here for about a year, and in that year, you tore down the hospital with no notice to either the people who sold it to us, who I've known for 50 years, or to us, the buyers. I mean, you did it under a notice of substitution, as if one institutional building was similar to another. Like a jail is comparable to a hospital, and it disrupts this whole neighborhood. I mean, all these people who have bought property that are senior-only housing, and the care centers here that could go across to the hospital without having to cross a main road. And that was all taken away because you can't, it's set up so no one is discerning the difference, and it seems kind of mindless and self-defeating. And the other thing is, if you were going to turn this all into a criminal area, why didn't you put the court here instead of miles away? It just doesn't make any sense. It's non-planning, and, you know, you just need to not be so quick to go through and change things that are completely, that people make economic decisions on and health decisions on. That, so I just wish you would be more careful and not jump the gun. And when someone tries to say something, you wouldn't do like the rat packing that I thought happened to us when we first complained in that initial meeting that you two were at, where they would listen to nothing. So anyway, Wachita has spoken, and I have what my great-grandfather used to say. So I wish you a good day.
Thank you.
Yeah.
Any other public comment? Questions? Do you need any action on this? It says possible action, but.
No, it's just a report for you guys to
Okay.
present it to you today.
Okay,
And so you
thank you.
keep apprised of what's going on.
Thank you, I appreciate it.
Thank you, John.
Welcome.
Okay, we're going to go to item 6M because at least one supervisor, if not more, has a memorial service or funeral to go to at 2. So item 6M, Senate Bill 1079, discussion and possible action relative to a letter of support for the subject legislation as it relates to authorizing the Director of the Department of Forestry and Fire Protection to allow advance payments from the Forest Health Grant and the Fire Prevention Fund grant programs for projects that create healthier forests and reduce the risk of wildfires.
I don't know who put it on, but I guess I'll address it.
Advance payments sound like a good idea.
Looks like what it is it's legislation that's intending to fix a problem they're having. CAL FIRE has recently come to the conclusion that its statutory authority looked at statutory authority and determined it lacks specific permission to advance payments of forest health and fire prevention grants. Been doing paying nonprofits on grants they were awarded. So they changed their policy to require nonprofits that have forest health and fire prevention grants to be reimbursed, but it takes like 60 to 90 days after submittal of documentation to CAL FIRE to get that money. So it looks like this this legislation would authorize basically the director of CAL FIRE to allow advance payments from the Forest Health Grant and Fire Prevention Fund grant programs. Probably would be quite helpful. Like a lot of fire safe councils trying to get grants because they don't have a lot of funding to front it.
Okay.
Greg.
Yep.
Any board questions? Any public comment? Then I'll entertain a motion.
I'll make a motion to have a letter of support for Senate Bill 1079.
I'll second that.
Okay. We have a motion and a second. All those in favor of writing and sending a letter of support for SB 1079, please say aye.
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 Aye,
Okay.
and then also could we give the person authorization to send that letter to whatever state legislators, agencies she thinks is appropriate.
Sure. Good.
At this point, I'm going to
Gonna
leave.
go? Okay.
Feel like they're having Judge Howard's
The only two things,
No, we have three.
So, Madam Chair, if I could,
Yes.
6J and 6K, I think
Yes.
were put on open session, but I think those issues with those two have been resolved. And so if
Yes.
the board has no objection, I would recommend just moving forward.
Yes.
Can we put them as one resolution, the two of them together?
Yeah, merge them in one
consider them
motion.
together, yeah, move them
Okay,
together.
well, I make a motion then to, and we can have public comment afterward, to award the RFP 1809.
(18-10).
-10 to Nexus Youth and Family Services. Authorize the chair to execute the agreement based upon the attached sample agreement
Okay.
on HHS Services Director completion of County Council's approval.
Okay, do I have a second?
I'll second that.
Public, just
Oh, yeah.
check on
yeah,
public.
Sorry, any public comment? All those in favor of the motion, please say aye.
Aye.
Aye. Let's see, and are you also handling item 6L, the procedures for investigator and legal runner?
Yes, ma'am.
Okay.
So what you have before you there is just a recommendation to approve this application and fee structure. I will let the board know that the Sheriff's Office, General Services, and the courts have gone over this. This information, we don't like to create stuff. We grab things from other counties, and the majority of this came from San Bernardino, and we modified it. Primarily, it's to get a handle on those legal runners. The courts, in there, you'll see two applications. The courts did the application for the investigators. We did the one for the legal runners. It's contingent upon council's review, though, because there are some new legislative actions that have come out. AB 1008, which talks about conviction history, and AB 168, which talks about salary information and what that looks like on an application. So it needs to get vetted out with council before we actually give the thumbs up for those things. Let's see, the funding structures are listed in there as well, and I think it's minimum wage for the legal runners and $50 an hour is what's recommended currently for the investigators. I do have, we had two investigators here in the audience as well, Mr. Fuller and Mr. Ambrose. I think
Don's still here.
Mr. Ambrose has left after a long day. But I did assure him that they hadn't had a chance to look at this, and they wanted to. But in its overall content, we're wanting to get it done to get a handle on some of the legal runner issues. But the court, if there's any modifications, I've recommended to both the investigators that, the court really has a lead. They're looking for us to essentially weigh in on some of this and weigh in on some of the in custody issues, which the sheriff has done. But if there are any changes, like with the fee schedule for investigators, which currently is at $50,
What page is that on? In this?
it would be on page 7 of 12. So it says initial funding for investigator services shall be limited to no more than $600, 12 hours at $50, and 12 hours at $50 plus mileage. We did do a survey of a variety of counties, 11 counties, and the low rate was at 52.29 and the high rate was at 57.14 when you do an average of all 11 counties. So if there needs to be an increase in that whatsoever, I can bring that back if the court recommends that after we meet with both investigators and the court, and just make simple amendments to you guys that go on consent. Otherwise, I don't know if Ambrose has anything else that he wants to add to that. I think
That was for the wages,
Pardon me?
57.49, that was for wages?
Average hourly
That was
rate.
average, but,
For investigators only, not legal runners.
We Yeah, for investigators, $50, but you set a limit of 600.
Yeah, the rules call for a limit of no more than 12 hours. So we've had instances where attorneys or investigators or folks will claim greater than 12 hours in a day. And so this puts a cap on that, some reasonable.
Would you like to speak? We'll open it to the public.
A place to sign in here, right? Yes.
Yes, please. Jennifer, I assume we have lunch back there, huh? That's good. Hungry.
I just wanted to point out that my name is John Ambrose, by the way, and I'm a private investigator. I'm a resident of Amador County. My business is located here in Amador County.
You addressed the board in the past on this issue, right?
Yes, I did speak to this issue the last time it came before the board. I don't remember the date. And I was assured then that both Mr. Fuller and myself would get to have some input into the proposal that's being put forth here today. I agree with Mr. Hopkins that this is primarily an issue that's dealt with by the court, and the board here probably doesn't have an awful lot to say about it. However, my main objection is to the fee schedule. I've been doing this now here in Amador County for 9 years, and I've been taking pro per cases and appointments from the court for that 9 years, in addition to private gainers too. $50 an hour has been, for that entire 9 years, the amount that I have gotten fee. I don't think it's kind of a unique situation where somebody else sets the fee that I can charge. The same thing applies to attorneys, I believe, in this county. The fee is set by somebody other than them. And granted that it only applies to appointments, such as a pro per case, or sometimes appointed to work with an attorney. Work is the same whether I get paid $50 an hour or whether I get paid my usual fee of $120 an hour, but you can see there's a considerable difference. Unfortunately, not a lot of people who are charged in the criminal justice system can afford to pay the $120 an hour. So I wind up getting most of my work comes from appointments. At $50 an hour, after paying taxes, office expenses, telephone, gasoline, etc., that doesn't leave me much. I don't make much more than the minimum wage, I don't think. At least one of you knows me well enough to know where I come from here. I was in law enforcement for 31 years, and I have a very good retirement. I am not dependent upon this income to live my life, but I do not like giving my time away either, and I don't think any of you would like to give your time away. The fee schedule that's been established has apparently been taken from an average of several counties. I didn't count them. Mr. Hopkins showed me the list. It is not an all-inclusive list of the entire state. Most of the county, well, I think every one of the counties that was included in that has a much larger population than Amador County, with the exception that in the average that he just gave you, I believe that he did add on Calaveras County, which I think is a fair comparison, but Calaveras County does pay considerably more than Amador County at this point. I also work in Calaveras County, so the law I haven't been able to actually find any law that applies to private investigators and fee schedules. Although 987.2 of the Penal Code, which is the basis for this proposed set of procedures, doesn't speak to private investigators either. It only speaks to attorneys, except that it talks about the rights and privileges of private investigators, but it says nothing in there about anything else. But it does in 987.3 of the Penal Code, the procedure for establishing a fee schedule for attorneys is addressed, and I would hope that certainly if we're going to be thrown into 987.2, that we should also be included in 97.3, which does not take into account an average of any other counties. It only talks about, when it talks about the fee, it says the customary fee in the community for similar services rendered by privately retained, and again, this is for attorneys, counsel to an indigent client. That's one of the things that needs to be taken into consideration. But you notice it says in the community. Well, the entire state and San Bernardino County is certainly not part of this community, nor should our salaries be compared to them, I don't think. So with that, I thank you for hearing me out, and I appreciate it.
So what would be a salary that you would more appropriate?
Well, frankly, I think that Calaveras County's fee is also too low, but I would think that this county should at least be in line with Calaveras County. You need to understand also, when you go into the larger counties like San Bernardino, that the private investigator businesses there are large businesses. I believe that Mr. Fuller and I are the only ones in this county who are doing this. We each have our own business. We have no staff to do administrative work. We have no corporate funding coming to us from anything either. We do not have employees that we can put off minor cases to at a lower salary or anything.
So what is
We
the
do all this
Calaveras
work.
salary?
$65 is what Calaveras County pays, and I think that that's a fair amount for this county as well. I mean, I'd like to get my full fee of $120, but
Really don't wanna know.
I realize that that's not going to happen. But I think that 65 is a fair amount. And I suspect that I'm probably going to have to address this topic with the court as well, rather than just here. And I do understand that.
Good information, though, John. Thank you.
Anybody else wish to speak?
Thank you very much.
Thank you.
So just so you know, we looked at 11 different counties. Not a lot of counties have procedures, by the way, on legal runners and investigators. So the counties we looked at were Calaveras, Butte, Humboldt, Lake, Los Angeles, Merced, Monterey, Napa, Placer, Riverside, Sacramento, San Bernardino, Santa Barbara, Solano, Ventura, and Yuba. Those were the counties that we could obtain information from the last time we met until now.
Take an average of those?
We did. The average low was 52.29, and the average high was 57.14. So, but as Mr. Ambrose suggested too, we can always review that with the court, but the court prefers that in this type of relationship that we address the county and what they consider as well. And if you have something different in mind that you want me to take back to the court, I can certainly do that and amend this if necessary.
Well, $65 an hour is not that different than the higher end of your average.
No, and they're not asking for
57.
the moon, that's for sure.
So out of those counties, let's see here. For example, Sacramento which is another adjacent county, their low is 4670 and their high is 60. And that county is about, I think, 1.3 million population. So,
And thousands of private investigators, which probably dictates the market.
yeah, these both these gentlemen I've spoke to, I believe, on the phone in my career here. I've always worked well with them. Never had any problem. They're local guys. So, like I said, if the board wants to consider something different, ultimately you paying the bill. We can certainly take something back to the court, and if you want to amend that, you can amend that now. If the court says yes, then we move on with life. We would perhaps, if you raise that, though, we're going to maybe need a little bit more out of our budget.
I was going to say, what fund does that come from? What budget does
Public
that come
defender.
from? Ah,
Yeah.
yeah.
It comes out of the public defender's budget. So question for John, how much did we pay to investigators?
Currently?
Yeah.
50.
No, not total per year. And
Off the top of my head, I don't know. I can tell you the legal runners, which is a core for all of this primarily, besides just the salaries for the investigators, we exceeded our budget by a little over $25,000. But that was not, the epicenter of that was not born on the investigator side. It was born on the legal runner side.
What is a legal runner?
Well, they take
Over
paper
for
from
the
the court and order the attorney, and they run it to their pro per defendant.
Okay.
They get paid for that time. That's why in these rules, other than, I can't remember if you need a high school diploma or not, but it's paid at the minimum wage, basically, because there's no qualifications necessary. They are really clearly and distinctly different than licensed
Investigators,
investigators.
yeah.
I don't want to put them both in the same group, although the process is linking them both
Right.
together.
Board, any other public comment? Wishes
Pleasure of the board.
Well, I guess, is our fee schedule in line with what it should be? Investigators, or?
Sounds like it's a little low.
Yeah, if you guys, I'm just providing the information to you. If you think it's a little low, Calaveras typically is a little higher when you look at per
That's
capita.
something that's going to break the bank, or what?
it's not going to break the bank,
No.
but and that's why I was asking, because it's going to be going from 50 to 60 an hour is 20% increase, but that's just for the investigators, and I don't know how much we spend on investigators.
Yeah, and what I can do is I can take a look at that, the expense, as well as what I suggested before. There are still two pieces. You guys can approve that contingent upon council's review of the application and those things I mentioned before, as well as our review with the court to see if the court has a recommendation of,
Fees.
although we kind of go back and forth, you're paying the bill.
Right.
So if you wanted to pay them $100 an hour, you could do that.
Was there another public comment?
The county does pay the bill, but the portion of that bill that deals with inmate cases at Mule Creek Prison is reimbursable. I don't know if the county actually bills the state or not. I have no idea how that process actually works, but the law says that it is reimbursable to the county.
Chuck says we do
Yes, yeah,
ask for
correct.
I
reimbursement.
thought probably so. And the other thing,
we don't do
there was a
anything
mention
for
of the $600 limit. That $600 limit was only on the initial appointment. That I don't have a problem with that. Some attorneys may have to have a problem with that, because then they'd have to come back and do another request to the court for additional or supplemental funding. But 12 hours doesn't get you very far in any investigation, I guarantee that.
And so what he's talking about, so the board understands too, that's out of our control as well, because the judge gives that order of how much time that the investigator or the legal runner is allowed anyway. And to touch on what he mentioned about reimbursement, we talked about this out in the hallway. There's a 60-day, net 60 basically, and that's important because some of these bills we've received are 6 to 8 to 10 months out before we get them, and if we're out that 6 months, we lose our opportunity for that reimbursement. So I want him to remember that.
Yes, please do.
Which I understand as well, but it's, some of the larger cases, that means that I have to bill several times, and again, I don't have a secretary.
Right.
So anyway, it's,
Board,
Well, if I knew what percentage of the cost was, I'd be all for going to $65, but
I can't tell you, I don't have the information to tell you what the dollar impact is of your action, and I understand I
okay.
can't.
Can we look at that in the future?
I think we can find it. Yeah.
Okay.
and then take away the reimbursable, so you'd have a net, what it was gonna
And that
cost
cost
us.
of the general fund.
Then I could make a decision pretty easily.
Okay.
So,
I'm all for it in
more
concept.
public comment?
Afternoon, Board of Supervisors, and I know it's really, really late for you. I'm Bob Fuller. I work in conjunction with the courts and with John Ambrose. And I want to make it clear, we're not here as adversaries to General Services or the court. In fact, John and I were the two fellows that says, you got to get this mess cleaned up. And I don't, there's a lot of history here. I'm kind of new to the area. I'm from LA. But they've gotten it cleaned up for the most part, and it's not on your side, it's on the court side and the legal runners and all that. And we're supportive of the efforts to go forward. We just ask that consideration be made for our services. John works cheap compared to where I come from, so I don't want to throw out my price, but you know, I'm semi-retired, so 65 is a reasonable sum for me also. Anyway, I just want you to know we support what they're trying to do here.
Okay.
It's just we would like to be able to talk and have some input to it also. Thank you.
All right.
any other public?
Hi, I'm Lori Whitaker, Senior Court Analyst for the clerk, and I was supposed to be at Judge Howard's funeral too. So I just want to say that one thing to keep in mind, Calaveras does not have a prison, and the majority of these pro-per litigants are from the prison. So let's keep that in mind.
Thank you. Any other public? Yes.
I want to make a distinction. The pro-pers at the prison are very different from the pro-pers at the county. In just a case in point, we get a case at Mule Creek. There's witnesses to those crimes committed out there, and before we know it, and this just happened to me, I go to interview a witness and I find that he's now in Calipatria. That's at the other end of the state. The Corrections Department has a tendency to move witnesses all over the state. We have things to deal with that are unusual to the county. So I'd like you to keep that into consideration. Thank you.
John, did you have something else, or do?
No, I just, how would you like me to proceed? And we'll go from there.
Shouldn't we adopt this this application and fee structure, at least for now, and
Yes.
then look at the fee for?
Yes, I would even recommend that, and based on those recommendations, I would also add, as long as county council says the applications submitted or modified appropriate to the law, right? As well as I can review the financial piece with Chuck, and if the court and you guys are in agreement with that, then I would say if there doesn't seem to be any reason, and we can talk with the investigators as well, reason not to go to $60 or $65 an hour, that we be allowed to do that, so we don't have to necessarily bring it back, because there are two minor pieces
Right.
there to finish
I
this.
think, sounds to me like we're supportive of that.
So you need a motion to approve the application process and fee structure?
Correct, with those other things I said.
Yeah, after approval by the legal.
With $65 as the number?
Yeah, I would say 65 is the cap, right?
Yeah.
And if
Right.
it- Right, okay.
So we're including the change.
You're authorizing,
John and Chuck.
Chuck and I to review the financial piece of that, and if it makes sense, if it doesn't make sense.
We'll bring it back.
We'll bring it back,
Okay.
okay?
Okay.
That,
So make a motion to approve the application process, fee structure for the runners and investigators contingent upon county council's approval of the application questionnaire.
and authorizing staff
And
to
authorizing staff.
increase up to 65 if,
Increase the for
Investigators.
investigators up to 65.
Correct.
I'll second that.
All set?
Yes, you will.
Yes, I will.
All those in favor, please say aye. Aye.
Cool, thank you.
Okay. Are we here? Are we ready to,
Thanks for hanging in there, guys.
what's that? Oh, yeah, we need
Minutes.
approval of the minutes, and then we'll go back into closed session and lunch.
Yeah, I didn't see any problems. I'd move to approve as presented.
Okay, all those in favor, please say aye.
Aye.
Aye. Any opposed? All right, thank you. The board is adjourned into closed session.